And this application is brought by a person that's incarcerated and brought false allegations and self-profiled allegations by the state and the media. And these profiling has enforced an injustice process that I am currently incarcerated in. I request the court to take note of my access and disability that is being forced by the respondents in this application. I request that the court give me an opportunity as a human to hear me out, as I request access to state my side and basically defend my main application as the reason for putting this application before the court as an urgent application, Your Honor. Your Honor, my urgency for this application, under Rule 612 of the Uniform Rule of the Court, Your Honor, I state that, Your Honor, it's highly impossible for me to meet the practice to request the court to accept the practice deviations because of the fact that I'm not able to meet the normal required court rules, because of the fact that I have a main application that's already on a normal rule, which is under Rule 6. And because this application that I present before this court is to enforce constitutional rights that I'm not able to actually have a defense on the main application, I request the court to consider under Rule 612 that I be granted urgency on the basis of that I have lack of resources to be able to take a normal course. And also, Your Honor, the application is brought by a person that's absolutely under not normal circumstances, Your Honor. And I'll give grounds to the unnormal circumstances that I bring this application before. The main application is of a person that was deported out of a country in Tanzania with false documents issued by the Home Affairs that confirmed that this deportation was not lawful. And in that also, Your Honor, is that my incarceration is also in question. It is also found that, Your Honor, that in this main application, that I cannot further give any context to it because it's a matter on another platform, but on another court. But the issue is fundamental, that I am challenging the lawfulness of my imprisonment, and I'm also challenging the lawfulness of my deportation and my arrest in Tanzania. And in that, Your Honor, I am not able to self-represent myself without having a lack of legal resources. And because of the lack of legal resources, I am not able to defend my main application. I'll take the court into.
What legal resources do you need?
Your Honor, I require access to a laptop to type.
I'm not giving you a laptop in an emergency. So I'll give you access to hard copy books, but I'm not giving you a laptop. You can have access to hard copy.
But Your Honor, you haven't even heard my application. We are making a decision up front.
But you are not giving access to.
For what reason? Which constitutional reason do you give to deny me access without hearing my application, Your Honor? That is prejudice of you not to allow me to.
Let me talk. You will get law books, Mr. Bester. They are the same books that every jurist in the country, pre a certain time when laptops became the norm, used. I used them when I started practice 30-something years ago. They will give you access to all the information you need for purposes of preparation of both your main application and your defense in the Free State. And that is essentially what you want. So you will get access to.
Can I finish my application? Can I bring my application before the court?
You can make your submissions, Mr. Bester, with pleasure.
Your Honor, I would like to take the court into the processes that I've gone through to bring this application before the court, and also reason why I've requested for a laptop or access to internet or information, as access to information is a constitutional right of anyone. And also,
you don't have a constitutional right to a laptop and a modem, Mr. Bester.
Can I finish?
No, I'm putting it to you. Show me where in the Constitution it says you have a constitutional right to a laptop and a modem.
Your Honor, I do not have a constitutional right to that, but I have a constitutional right to access to court. And the resources can be limited, as a right to an inmate can be limited under limitation. And under those rights, Your Honor, there are access to laptops and modems in prison currently to students. So are you saying that I do not have a right to access court?
A student, Mr. Bester.
No, Your Honor.
I'm giving you access to law books. All the material you need I will give you access to. They will just not be electronic.
Your Honor, I have evidence in the main application that has to be seen, that is visual evidence, which is press briefings. It's also in the responding papers of the main application where the respondent states that I have not added those press statements that I've put because of the fact that I do not have access to them and I have not watched them. And how am I going to watch them when I'm in CMAX, when I'm incarcerated? And the fact that I have no resources to access those evidence. And the application is based on the following. But Your Honor, you've thrown my application out of court without me giving you background.
No, I actually haven't, Mr. Baster. I'm telling you, I'll give you the material you need. I'm just not giving you electronic material.
That's biased, Your Honor. Because you haven't let me finish why I stated the application.
Mr. Baster, you want...
And you are defending the application as the defendant. You are not giving me an opportunity to justice, Your Honor. You are blocking me. I'm putting my submission. You can allow me at least to finish my submission and then throw it out.
You are welcome to make the submissions, Mr. Baster.
Okay.
As I've said to you, I will give you access to material.
Okay,
you are welcome to.
Can I continue to make my submission?
Mr. Baster, don't be rude in my court.
I'm sorry. Can I continue? Can I make my submission?
Mr. Baster, be polite and different in a court of law. Please don't stand there and roll your eyes. It is really unbecoming. We are having a debate here. That is what we are doing. I have given you my prima facie view. I'm going to give you a full opportunity to place your facts before me. But you will need to convince me that you require access to a laptop and a modem for purposes other than what hard copy material cannot give you. That is in your papers, Mr. Baster. All right. Please continue.
Thank you. Your Honor, I also bring the fact that I'm self-represented in both applications, which is this one. Your Honor, I have lodged the application on the 13th, which was commissioned on the 13th of August. Because of struggling to get third parties to assist me to file the application online, it was very difficult for me to bring this application. As you would see that the respondent used the fact that the delays of dates of the sit-down because of the fact that there were missing applications and missing documentation in my submission. And because of that fact, Your Honor, is that I do not have access to court because I cannot file an application without anyone assisting me. I'm also in a position where I'm disprivileged because of the fact that I have 2 visits a month, which is 30 minutes a visit each month. And I'm also limited to legal resources because every legal counsel that has to see me must make a booking based on availability, then that would be granted. So meaning that if I have to submit or access any information, my resource of accessing information is limited because of the rules and regulations that are enforced on me at CMAX. And because of that, Your Honor, I cannot file an application as I wish. I cannot take any litigational facts as I wish at any point to access the court. The court is digital. And if the court is digital and I have to use a third party to file an application in this court, it makes it impossible for me in my current circumstances. I'm not asking for a free will access to internet. I will showcase the court that access can be limited and can be secured in an environment that I'm currently in. It is proven by other courts and other prisons that has enforced the same laws. And access to court, Your Honor, is very fundamental to any person that is incarcerated. It is irrelevant or important to insist that only students are privileged. It's discriminative and it's not equality to everyone, because access to court brings fairness to all. Because, Your Honor, without access to court, I cannot fight for my own freedom, and my liberty is at question at this point. And I am requesting the court to assist me to access court. That is all I am asking the court. If the court can make any arrangements that I would be able to access the court, I have no problem. I will state in the following, Your Honor, application. I had requested that head of prison assist me on typing documentations at the center. This application was disapproved. I was informed, and I have a copy of the application, that I was informed that I need to send the application, whatever I handwrite, to someone to type. I have limited resources in reaching those people, and also getting to those people to give me those applications and type them and bring them back. By the time I file an application, I would already be out of the time frames that the court requires. And in that, Your Honor, I have placed these issues of access to information of hard copies that took me an average. I was only allowed from November on the 16th by the head of prison and the area commissioner to be allowed to even receive a novel. I am denied access to a diary at the current state that I am. I am denied access to information that involves any information that is printed that brings question of evidence of where it be printed by the media. It's been rejected by the current respondents, Your Honor. I have not been able to access that information. And currently, Your Honor, I cannot in any way access that information. It is proven by the respondents' answering papers in the main application that my papers are incomplete because of lack of evidence. The lack of evidence is fundamental to my liberty. And all I am asking the court, I am not asking for access because it is access to laptop or modem based on the fact that it is the only resource that I need. It can be in any way. It is also proven in a case in 1977, which is Boss versus Smith in the Supreme Court of America, that a fundamental right to any imprisoned person is to access the court. It is the responsibility of the prison authorities to provide trained legal assistance or library that has legal resource. I am asking for these accesses that are not available at the current facility that I'm at. The best fundamental option for me to be able to manage my defense is to have access to something that I would be able to present before the court. And that's what I'm asking this court to take into consideration. I will also go into the following acts that I feel are infringed. If I am not able to bring an application before the court as fair as anyone else, it means that Section 9 of the Constitution is directly infringed by the respondents, which means we are not equal before law and that I am not protected and I do not benefit from the same law. And in this current stage, if I am out to get hard copies, Your Honor, it is proven by the correctional officials of the United States where this order was granted. In 2010, it was taken by Lennox and Nix that all hard copy material is fading out and some material is no longer available in hard copy. Another fact is that, Your Honor, court is only available online. The evidence that I require is available online. The access to internet is a completely different factor to what I request. I request access to resource. The resource can be a device that at this current stage can be easily monitored and managed and controlled without any security risk by the respondents, Your Honor, because of the fact that they have 2 members outside my door 24/7 of EST, highly trained. They supervise every single thing I do. I am showering in a cage. I exercise in a cage. I am completely by myself. There is no way I can access anything without them being next to me. There are cameras outside my door. I am asking for a very minimum in this current situation that I request access to a device, even if it's without, so that I can type and view this press briefings that were made that said that Thabo had to be deported or whatever reasons, so that I can type the key factors that I want to use as evidence to the unlawful deportation application that I have put as the main application. And because of that, Your Honor, the court must take into consideration that 90% of this case, of the main application, the state has trialed it in the media, meaning 90% of the information is not accessible to me. And most of the allegations I don't have access to. I don't even get a newspaper. I don't have a radio. I don't have a watch. I don't even know what time it is. That is how I've lived for the past 16 months. So this privilege and my circumstances of incarceration enforces me to try and fight for myself. And Your Honor, I believe that any person has a right to fight, to have legal and fair process to access the court. And all I am asking is to be able to put my application in proper manner. If the court is able to arrange that I have access to this, to the required documentation and the required evidence, I have absolutely no problem. But at the current stage, there's a direct infringement on Section 32 of access of information. I have no information. I'm only allowed certain information that's approved by the area commissioner, and through that, I cannot access whatever information I would feel relevant to my application. I cannot access any administrational case that I want to pursue with the court because I would need a third party to assist me. And that third party would rely on financial resources and also rely on strict limitations by the respondents, meaning that I have a very limited resource in getting visitation, be it legal or otherwise. And second and fourth, Your Honor, it's access to court. The access to court, to me, is an absolute, because I don't have access to court if I don't have assistance. If you give me books, I can read the books, but who's going to do my application? Who's going to file my application? I would depend on a third party. And dependent on a third party, which is evident in this application, has become the cause of my application being delayed from the 13th of August. It was an urgent application that had to sit on the 16th of August. And we are now in September. It's nearly a month. And the respondent lashed on their papers that it's my doing and my self-creation of urgency. And it cannot be on my self-creation of urgency because, Your Honor, I had filed the main application. I had drafted and given briefs to 4 counsels that have rejected the briefs based on the fact that they felt that they cannot represent me because of the media carnage that is currently existent in my case. And they will not put their reputation according to that. And in that, it forced me to file this application on my own. I have even taken further steps to try, after filing the application, to appoint counsel. But the counsel I seek is a counsel that's an expert in international law and in immigration law. And I have not been able to obtain that, John. And all I am asking the court is to take in consideration that I have followed all required processes within correctional services. And even correctional services themselves know very well that I have tried my level best to try and request law books. I am limited. I am limited to what I receive. I am limited to what I can receive. It is the discretion of the respondents that decides what I can receive or what I cannot. If it does not meet whatever security understanding they have, I don't know what media information has security issues, Your Honor, but it is a direct injustice to me, Your Honor. And I feel that under Section 38 of the Constitution, that I have highlighted how many constitutional rights of mine have been infringed. And if the court feels that to access court can be done in any other way, I am more than willing to accept that. But at my current position, I cannot see how I can type a document without accessing a device. I cannot see how I can file an application without being given access or without somebody assisting me to access to file online. And those are things that are currently existent in the responding papers of the respondents. They lash at my application based on the fact that I do not have resources. I cannot, unfortunately, enforce these requirements on the respondents. I have to bring it before this court, and the court has to make a decision. If the court feels that I cannot access it, I'll accept. But I will say that it would be an injustice to my main application where I seek relief for unlawful deportation and unlawful imprisonment. It would mean that I'm deprived for defending my own liberty. And that is, to me, an absolute, as noted by the Supreme Court, Your Honor, that if a person challenges their detainee, and the authorities cannot justify why the person is there, the person must be given access to court. And I am asking for access. That's all I am asking. I am not asking for luxury. I'm not asking for anything beyond that. Access to internet, Your Honor, I will bring it to the court that access to internet currently is available in about 240 prisons in America. That is limited. And access to court has been brought by the fact that correctional services in the United States have taken a decision that print material is too expensive, or legal assistance for inmates in prison is too costly for prisons. And in that, they have allowed inmates where companies like Alova has designed a specialized device that I can submit to the court these documents, that they've developed a specialized tablet. This tablet has secure 100% access only to court education and rehabilitation programs. And there is no way an inmate can use it for any other way. And this shows that correctional services itself can be innovative in providing me with access to court without having security risk. A device in a person, as it says by the United Nations, as it's an international human rights to access to internet. Limited access to an inmate can be provided securely, especially currently with AI being available, where where the authorities can manage and control any information that is controlled, even every key that an inmate touches on a device because of the AI, and it will report immediately for human supervised if the inmate misuses the device in any way. The inmate is limited to which sites can be accessed. Access can be only to a court and to file and access to certain sites, as for example Linux and Next, which is to subscribe for information by law. And that is something that has been proven. And none of these, it's been available from 2010, Your Honor. And none have any security breaches up to date until today. It's even improved by Australia, where they have enforced the same access, where they have allowed inmates to have access to tablets. And these tablets are limited to which access to internet an inmate can have. And all I am asking is access with limitations. I am asking for access as a resource to bring my application before the court. I am not asking that the court understands that access to this is fundamental to a person who is in my position. If I am not able to defend myself, it means that I am deprived of defense. And it's our constitution, and it's guaranteed in the constitution, that I have a right to protection and benefit as anyone through the court and the law. And I am asking the law to look at this matter and look at the limitations. The respondent currently, as I have stated, provide students with access. This access already brings the risk that they bring up in this application. The risk already exists. They are able to put security measures to manage that risk. There is nothing untowards that I would bring that is new, that security measures cannot be put in place. I am the most guarded inmate in this country, Your Honor. It's highly impossible that correctional services would not be able to supervise a device and limited access. And all I am asking is access. That is all I am asking. Your Honor, I will take the court also to understanding that the security measure that is brought up by the respondents in question to my application and access to legal resource is as follows, Your Honor. That in Finland, Denmark, and Belgium, Your Honor, there's systems that have been placed to have access, but the access is limited. This system is called the server, where the correctional services have something called Prison Cloud. Prison Cloud allows you access to court, allows you access to resource, but it does not allow you access to anything else that the respondents or the prison authorities will not approve. And based on that, it makes it accessible for a person to put an application before the court. And all I am asking the court to give me is an opportunity to use the same measures, because the respondents are a large department where they have more than enough resources and IT experts to be able to provide me with the same access. And all I am asking is the same access. There's no one who's more privileged in prison and who is less privileged. We are all equal. And that is through the Equality Act, Your Honor. And I believe that if I am denied based on the fact that I am not a student, I wouldn't want to be a student just for the sake that I want to put an application in court. I want to put an application in court as a legal resource. And if I no longer have an application in court, then the device can be removed from me. If I infringe on any of those, it can also be removed from me. But at this current stage, Your Honor, I see no reason why I cannot put my own application and argue my own application as best as I can. And I feel that at this current stage, I am treated unfairly because I approach an application and already I am faced with a circumstance where I am not feeling that I am given an opportunity to hear, where I can argue and put facts before. And if the court, because I was not saying that this is the only resource that would make it accessible to court, but it should be able that when a person does not have financial muscle or financial resources, they should be able to access the court and argue whatever they wish for litigation. It's a constitutional right. And if that access is moved digitally, then the prison has to move digitally. It's proven by what I've brought before the court that other prisons around the world have taken the same process, because everything is turning digital and print is fading out. There is no longer as many newspapers as there used to be, and there probably won't be for very long. So I am asking the court to take consideration that access to digital resources in prison is not a violation of human rights. It's not a slap in justice's face. It's not a disrespect to this court or anyone. It's just a humble plea that I request access to court. And if that is denied, then it means I do not have access to justice. It means I don't have access to court, because if the court says that I should only access books, you're still limiting me, because it was proven in Denmark that access and meaningful access are two different things. I do not have meaningful access because I depend on someone else. It is also stated in the urgency application where the respondents questioned why we took so long to file. My assisting attorney to do correspondent, her laptop and cell phone was stolen at the prison. She was not able to file. There's a case number in everything. The correctional services are fully aware of this fact. But what I'm trying to say is that I am now dependent on another person to file an application. Even getting to this court, I had to physically try and request numerous assistants to get just the requisition to the respondent. And I am saying that this should not be the case. I should not be struggling to access this court. I should not have to come to this court to ask for a basic right, because it is a guarantee through the Constitution that we are all equal. I do not feel equal at this stage, with respect, Your Honor, that I was bringing an application and I felt that you were attacking me without giving me an opportunity. But I apologize if I offended you. But the bottom line is that I really just want access. It does not matter what form or what measures the respondents can bring, as long as it's access. They know very well, outside the allegations that have been brought, that I face currently, and the unfounded allegations of charges, I have, for a numerous time, have not infringed on any of the acts or regulations of correctional services. I have not been in any way difficult to the correctional services. I've complied with every rule that they have put before me. And there is no evidence that they can bring except allegations that I have not complied. And all I'm asking you, Your Honor, is that
Thank you, my lady. My lady, just so that I'm clear with my approach, I don't intend to be long. I don't know if my lady still has agency as an issue in this matter.
Well, I understand that is an issue.
Yes.
Yes. Mr. Bester has addressed that.
Yes.
During the course of his argument on the merits. So
Yes.
certainly welcome to touch on that.
Yes, my lady.
It seems to me that the application is founded on the fact that books are going to be insufficient to provide him full access to court.
Yes.
And that he requires a device for purposes not only of the research that he talks about in his application, but typing documents and uploading them to the electronic media platforms that some of our courts in this country use. So perhaps during the course of your argument.
I can address that. Thank you. Thank you. My lady, may I just seek leave to just place one thing on record, but the matter is now in full swing. The hearing, my client had intended to file a supplementary affidavit consequent to the filing of the replying affidavit, but to also address further matters consequent to the information that they received this past Friday, the 13th, and consultations were held on Sunday, and those papers were prepared yesterday. Yes, my lady, that is what I should have done as I was sitting down, but I did not want to interrupt the applicant in his address because I omitted to say that. But I'm in the hands of the court because the application for leave to file those documents was intended to be heard this morning. Unfortunately, it was not filed timeously, only filed this morning. So I don't know what yes.
I wasn't notified, so
Yes.
I haven't seen those documents.
Yes, my lady.
Are they on place lines? Does Mr. Bester have an opportunity?
I'm informed he was only also served this morning. They were uploaded on court online, but yes. Yes. But that is why, my lady, I'm saying I'm in the hands of the court if the court is of the view that the matter should proceed.
Where will I find this?
I'm informed it was uploaded on court online this morning. Yes. Perhaps I should address the issue of agency. I don't know if the court wants to determine all the issues together.
Determine all the issues at the same time.
Yes.
How impactful is this new evidence solution based?
My lady, in my client's view, it is material to the issues to be determined by this court, particularly in relation to the concerns raised by the respondents on the merits of this matter and the security considerations. If the applicant is to have access to a laptop and a modem.
Do you have a hard copy with you?
My lady,
I'm not accepting it at this stage.
Yes.
I want to see what it says before I sign it.
yes. My attorney has it, but it has not been compiled properly, not stapled.
It's fine.
Yes.
Yes, Your Honor.
Then this matter is not right for you.
So, Your Honor?
It's not not right for hearing. You're going to want to respond.
Yes.
How long do you need to respond?
So, Your Honor, before I respond, I actually, on my side, I argue that it's unfair, Your Honor, that to even accept the papers, Your Honor.
That's why I'm asking you if you want to respond to it. I haven't accepted them.
Okay, I'd like.
That's what I said to counsel. I'm not accepting them. I want to see what they say.
Okay.
So they are bringing an application to ask to allow them to formally file. I assume you will want to respond to that.
Yes.
That's what I'm asking.
Yeah, I can
How
respond.
long do you need
To respond to their,
to this application for the further evidence?
as in if the court accepts it.
Yes.
Oh.
In general, because the court must decide whether to accept it, and I assume that you would want to file a response to say why it shouldn't be accepted.
Yeah, I would. I think I'm prepared, Your Honor. It's fine.
So
There's nothing I can
you
do.
will just argue. Just remember, Mr. Bester, I can't hear your evidence if it's not on affidavit. This isn't a trial.
I understand.
So you will have to stick to your founding affidavit and the replying affidavit you've already filed.
Yeah, Your Honor, but if I have to do that, Your Honor, it means that I would have to write in hand and submit in hand.
Then that's what you must do. I'm giving you that opportunity.
Okay, how long will I get to do that?
As much time as you need. I can simply remove the matter from the roll and you can set it down when you're ready.
Okay. No, if you can give me an hour too.
An hour.
Or do you want to give me a long time? I don't know.
As much. Tell me how long you need, Mr. Bester.
2 hours is fine.
I think rather what we would do is stand that down on Thursday morning. That will give you a day to file a response, and you can file by tomorrow morning at 10, and you can file by a reply if you need to by tomorrow at 5.
Sorry, Your Honor, can I just ask a question? Would I have to file online? That would be impossible by Thursday. Your Honor, I would have the assumption that it's fine. We can proceed now. I'll respond now. It's fine.
But, Mr. Bester, that's fine. Just understand, you must stick to what you've already said in your founding and replying affidavit. I'm not allowing submissions outside of that. You've
Okay.
made a lot of submissions now outside of that. And I've allowed it, but it's not admissible in front of you. It has to be under oath. You've made a lot of allegations about countries like Belgium and Sweden and the USA and Australia allowing devices for prison. That is not admissible evidence. If it's not an affidavit, I cannot accept it and I won't accept it. Those are the rules of this court. That's why I asked you. You want an hour or two, I'll give you an hour or two.
Okay.
But if you want longer, then what happens is this is the procedure. I remove the matter, and when you're ready, even if it's in a week or 2 weeks, you can set the matter down for hearing again. It doesn't mean it's urgent. That judge will decide whether it's urgent. But I will give you the opportunity to respond. That is your right.
Okay. Is the court saying you are accepting the application?
No. I'm saying I'm giving you the opportunity to file an affidavit to say why it shouldn't be accepted.
Oh.
And to respond to it in the event that court does accept it.
I understand, Your Honor.
You understand? If you don't want that opportunity, that's fine. Then I will make a decision myself on whether to accept this new evidence. But then, as I say, Mr. Bester, and this is why I'm repeating this for the third time, you are bound to your founding affidavit and your replying affidavit. That is the evidence you give this court under oath. I don't accept evidence outside. That's why I'm asking.
It's fine, Your Honor. We can
What do
proceed.
you need?
We can proceed.
We want to proceed. Right. Then I'm going to stand this matter down because I want to fully read this application. Remission of supplementary evidence. I have other matters to attend to at 10 o'clock. My secretary will inform you at 1 o'clock where we are. The alternative is that I can stand you down on Thursday at 10 o'clock.
Yes. Alida,
See you at 10 o'clock with this matter.
yes,
Sorry, Your Honor. If that's the case, if the matter is put down, would I still have the option of filing an affidavit or not?
Well, you must decide, Mr. Bester. Are you filing or you're not filing? That's what, Mr. Bester, you and I keep going around in circles. If you want to file, I will give you the opportunity.
Yes, Your Honor. But the main reason why I'm asking is to understand if the matter would be separate from today. The reason why I want to proceed because I'm already on condemnation on the main application. So if any delays are enforced further, I'm even more disadvantaged, Your Honor. That's why I'm asking the court. Would it be a matter if the court has to read the application? Will we still proceed today, or would it be a matter on a different day? That's why I'm asking.
Proceed today, but I need an opportunity to read these papers, and I have other matters waiting. So I must tell you those matters. I can read this at 1 o'clock, and then I can tell you how far we are. And I can try and fit you in sometime between 2 and 3 o'clock this afternoon. Then we can finalize this matter today.
Yes. Lady, I just wanted to say that if Mr. Bester is worried that his time for filing a replying affidavit in the main application has run out and postponing this matter to Thursday will put him in more trouble, I can just take instructions from my client, because I think in any event it was going to be a sensible thing that his time for filing the replying affidavit should start running whenever the order is given in this matter. I would presume that that would be a sensible thing. So if he was going to have 10 days to file it, ordinarily he would still have that 10 days. I can't see that there will be prejudice to my client. Yes. So because I'm just thinking on the question of practicality and also accepting that, you know, on the part of my client, the court is only getting the application today. So if Mr. Bester has it, he can consider it, the court can consider it properly, and then in the next 2 days, literally, we can all be back here and know that all the housekeeping issues and all the matters are dealt with properly.
Mr. Basic, do you understand?
Yes, Your Honor.
So, Mr. Masibuku says your main application won't be in jeopardy. You will only be the time within which you have to file your reply affidavit in the main application will only start running from the day this court gives an order. So you won't have to worry about the
Okay. No, it's fine, Your Honor. If we are given till 2 o'clock, 3 o'clock, I think by then I would also even draft my own affidavit. If it's today, if it's on Thursday, it's fine. I'll also put my own affidavit to respond.
Mr. Bester, I want you to think about the time you need, because I don't want an argument later that you weren't afforded a proper opportunity.
Yeah, no, I'm fine with 2 hours, Your Honor.
All right. Then this matter will stand on.
Thank you. Lady, can you in the meantime just ask my attorney to properly compile those affidavits? Yes. Thank you, my lady.
So now he's been given the opportunity to
defend my main application as the reason for putting this application before the court as an urgent application, Your Honor. Your Honor, my urgency for this application, under Rule 6.12 of the Uniform Rule of the Court, Your Honor, I state that, Your Honor, it's highly impossible for me to meet the practice to request the court to accept the practice deviations because of the fact that I'm not able to meet the normal required court rules, because of the fact that I have a main application that's already on a normal rule, which is under Rule 6. And because this application that I present before this court is to enforce constitutional
needs the laptop particularly for purposes of the criminal trial to access the docket for the deportation and the criminal case. So, but the Free State High Court application is also important for purposes of this matter, particularly in relation to agency. My lady would have noted that the main application, the deportation application, was launched on the 12th of July 2024 already. And on the 24th of July, yes, Mary, that is in this particular application. But now I'm referring to the deportation application. Yes. My lady will remember that this application is essentially ancillary to the deportation application. So for that application, which I refer to as the main application, was launched on the 12th of July 2024. And
those papers are yet to be finalized?
Those papers are yet to be finalized. What is outstanding in that application is the applicant's replying affidavit. Then, my lady, this application, the current one, the urgent application, was filed with the registrar of this court on the 20th of August. That is a month or more after the main application was filed.
Well, according to the notice of motion, the matter was sent down on Friday the 16th of August.
Yes. But
and it never proceeded.
It was never set down, and as a matter of fact, the respondents received those papers after the date of the intended hearing, that is after the 16th of August. Well, my lady has to an extent heard what the applicant has had to say about that. And he says he was struggling to have the papers filed. but there are still problems with agency, my lady. Why do I say so? Because on the 24th of July 2024, the Free State High Court application, 24th of July 2024, the Free State High Court application was launched. And at that point, the applicant should have surely appreciated that he would need a laptop also in the main application. As a matter of fact, he should have appreciated even before he launched the main application that I'm going to have a problem because I'm acting in person. I need a laptop. The main application was filed without any problems. In the answering affidavits, the respondents make that point and the applicant does not deal with it. The applicant similarly was able to prepare and file the founding papers in the current application. He does not particularly explain how that happened, except making one statement that he has had to rely on family favors. He does not articulate those favors and how he was assisted to file papers in this court. The point that I'm making, my lady, ultimately is that the applicant has access to court. And the reasons why he says this matter is urgent, my lady, he says because the notice to oppose has been filed by the respondent's attorney, the state attorney, now suddenly the application is urgent because I have to file a replying affidavit. He says he needs to research also for purposes of drafting heads of argument, but the respondents make a point again in their answering affidavit that in the main application, the applicant in fact refers to international authorities and other legal authorities. He does not deal with that allegation also in his replying affidavit. Well, there's also a lot of things that the applicants said before this court today from the bar, which are not in the papers, but it is striking that he referred this court to information about Finland, USA, and all those other countries. How does he have access to that? How did he get access to the legal authorities which he refers to in the main application? The agency, my lady, in my respectful submissions, is clearly self-created. And that is based on the simple fact that the applicant, on his own version, waited until the notice to oppose was filed before launching this application. My lady will not see anywhere in the applicant's papers where he says, before I filed the main application, I made a request for a laptop and a modem. He does not say so. He only makes a request on the 6th of August 2024, after he had already filed another application in the Free State High Court pertaining to this issue. These delays, the manner in which the applicant has approached this matter, particularly in relation to agency, are not explained in the founding affidavit. Neither are they addressed in the applicant's replying affidavit. And the consequence, my lady, where agency is self-created, authorities are clear, is that the matter should not be accepted on the court's urgent role, because self-created agency is in fact, bluntly speaking, an abuse of court process. And I will therefore, my lady, move that this matter be struck from the roll for lack of urgency. But if your ladyship is so inclined to accept the matter on the urgent roll, which I still contend should not be the case, this application should nonetheless fail on its merits. And some of the submissions that I made in relation to urgency will apply to the merits, my lady, because I said earlier that the applicant has in fact been able to access court. So, as a matter of fact, there is no limitation whatsoever on his right to access to court. The problem that we have is that the applicant suggests that he should have access to court in the manner in which he wishes. He does not want to have access to printed authorities or textbooks. That much is clear, because according to the submissions that he made today, print media fades. But my lady was quite correct. Even today, we still use printed textbooks. Many advocates that I know still wish to have law reports, physical law reports in their offices. So with respect, there is really no substance in that submission. And I must emphasize this point, my lady. My lady will see that in this matter, we are not dealing with an inmate who does not have resources to appoint attorneys. Far from it. The applicant, in fact, informs this court in his replying affidavit that he has attempted to employ at least 3 senior counsel who did not accept his brief. He also makes a blunt allegation that he has on numerous occasions attempted to appoint counsel who refused to assist him. But my lady would have seen in the supplementary affidavit that in the Free State High Court application, the applicant is represented by an attorney and an advocate. If they are willing to represent him in that application, which is similar to this application to an extent, why would they not be prepared to assist him in this particular application? Of course, the applicant elected not to file any affidavit in response to the supplementary affidavit, and consequently has failed to explain why those legal representatives cannot assist him in this matter. He also does not explain why an attorney cannot assist him in this matter, because as I understand from the replying affidavit, it is only those 3 senior counsel who are apparently specializing in international law. We don't know their names, and the numerous other advocates who allegedly refused to assist him. We also don't know who those advocates are. But the court would have seen, again, in the supplementary affidavit, the numerous visits by various legal practitioners to the applicant. And in fact, the attorney who is apparently assisting the applicant to file papers in this court in this matter, it is the same attorney who is representing him before the Free State High Court, and the same attorney who has visited him at the CMEX, as it appears in those papers. So there is really no limitation of the applicant's right of access to court. He's exercising it, but the respondents have explained why the applicant further, despite the fact that there's no limitation, why he cannot be allowed to have access to a laptop and a modem. Of course, one accepts that the prisoner retains all the other rights which are not limited by the invariable consequence of imprisonment. However, in this particular case, the applicant has been able to exercise his right, but the respondents have explained the security concerns pertaining to allowing the applicant access to a laptop. My lady, I don't need to recite the evidence. It is well known. It is there in the papers. The applicant did not deal with it, that he escaped from a maximum security prison in Bloemfontein. It's there. And in fact, the main application relates to the circumstances pertaining to his deportation following the escape. So really any denial of those facts is, in my respectful submission, untenable, if not disingenuous. But in the supplementary affidavit, the respondents deal further with the conduct of the applicant when he was still incarcerated at the Mangaung Correctional Center, the fraud that he, together with Ms. Magudumana, perpetrated whilst he was in prison. So the respondents are not merely raising security concerns in rhetoric. There is evidence to back those concerns up. But again, my lady, I submit that the court does not even have to get there, because there is simply no limitation of the applicant's right to access to court. And on those bases, my lady, I respectfully submit that this application should simply be dismissed. Yes, my lady, as far as costs are concerned, I will not address the court on that. As the court please. May I just take instructions, my lady? Thank you, my lady.
Yes, please reply.
Your Honor, in relation to the supplementary application or affidavit that was submitted, I have it in hand. This is my reply, but unfortunately it's not commissioned, number one, and I have annexures that are to it that needs to be copied, and I need to have a copy. This is my original. So there's no way I was taken while I was writing, and I was not done.
I understand that, Mr. Bester, but if you recall, before we adjourned, I gave you 4 or 5 opportunities to stand this matter down, and you chose to be here at 2 o'clock. And that is, unfortunately, that's where you now sit.
That's fine, Your Honor, but at the end of the day, I can't submit an affidavit that's not commissioned. It's also not commissioned.
And that is why you were given 4 or 5 opportunities, Mr. Bester. So we are here because you insisted we are here, and you will see. And if you recall, I explained to you several times that if you don't file an affidavit, you are bound to your founding and replying. And you insisted, despite me asking you several times if you want to stand down on Thursday, you insisted 2 o'clock, and it is now past 2.
Your Honor,
Please continue. There is no further affidavit.
Can I-
That was your choice.
can I finish? So I'm saying, can I finish what I'm stating? Please. The process of commissioning this, it's not up to me, Your Honor. I'm in a cell, and I have to get authorities to commission it. I have to get authorities to approve a complainant request to go and make copies somewhere else. It's not up to me to make those copies in my own cell. That is why we are here, Your Honor. I do not have access to those things. So I was not able to get these things commissioned. I was taken immediately to come here. I explained that I am not done in the sense of making copies. I was then informed I should request the court for a postponement, which is not in my doing. This copies, I have all my documents here. If the court wants to make copies for me, I have no problem. Do you understand? But at the end of the day, it's the process within prison that blocks me from making the commissioning officer is a member of correctional services. I have informed the head of prison. He did ask me to request for a postponement to get this affidavit commissioned. There's absolutely nothing I can do about that, Your Honor. And second, my annexures, which are pertaining to most of the allegations brought by the respondents, I cannot put them because they are my original copies. So if I submit them, I do not have any documentations with me. And that's basically what I need the court to understand. But and then moving on from there, Your Honor, I will address the court as the court wishes, but I do want to highlight that I feel that the court is being prejudiced towards me. Your Honor, dealing with the responding, a supplementary affidavit that's submitted by the respondents, Your Honor. As mentioned in my replying papers, that the facts of the alleged or allegations put that have not been tested by any court of alleged escape or alleged fraud cannot be entertained by this court because evidence has not been tested. It's allegations. And at this current stage, I am one of the inmates that are most in public have numerous allegations. None of those allegations, the respondents mention a case of fraud. I have never been charged for that case that the court has accepted affidavit today. Second, I do not have number of the supplementary affidavit that has been added. I do not have the annexures that are mentioned in the document. I do not have the so-called complainant's affidavit as mentioned. I do not have DCS 1, DCSA 4 and 3 and 5. I only have 2. And meaning that I do not even have proper papers to be able to respond to it thoroughly. And under the uniform rule of the court, under Rule 6(5)(e), is that there are 3 sets of affidavit the court has to accept, which is the filing affidavit, responding affidavit, and answering affidavit. And right now they are adding more affidavits, and the court accepts it. And I feel that that's prejudice to me automatically, because they should file a motion and add that information that they are placing before this court. I do not have access to test the evidence they are putting in the supplementary affidavit. Second thing, Your Honor, is that under Section 35I, is that I have the presumption of innocence until proven guilty. So these allegations that they are putting before this court, which is escape, has not been proven, has not been tested. The allegations of fraudulent charges against me or Mrs. Makutumana has not been tested. So we are basically speaking on hearsay evidence, and that cannot be tested by this motion court, because there are criminal matters and other matters that are before another court. And under my constitutional right, I have the right to remain silent. And that is a matter of fact that I cannot come and address that supplementary affidavit in this court, because those are criminal charges that are before another court. And the court accepting that is prejudice to me, because if the court has to look at the actual application, which is access to legal resource, and it is written in the filing affidavit as access to legal resource, and I refer to access to a laptop and internet. But I am not saying the respondents cannot limit, supervise, monitor these devices. In actual fact, I have highlighted today to the court that access to digital content it's not a new thing. It is something that is already managed by the respondents, and there is no security bridges in that sense. The respondent create their own security bridge because they are alleging that I have escaped. They say I have committed a crime, but they have not proven that crime, Your Honor. And I am now prejudiciously forced to comment on a case that is before another court. And I find it truly unfair for me to be before this court, have to answer for a matter that has not been tested. The affidavits added in the supplementary of the investigating officer and etc. I do not have them. The so-called statements from the complainant, I don't have it. And we cannot bring them to the box and actually get them to testify and see if this is relevant or not. There are numerous allegations, Your Honor, and I feel that, honestly speaking, with all respect, it would be unfair for this court to expect me to even touch on any of these allegations, because they are a matter before another court. As the advocate has mentioned, there is a case in Bloemfontein of escape, and that should follow its process. The respondents only based on legal resource is the basis that I am now before the court. But the court itself has in black and white that the matter was supposed to sit down on the 16th. It couldn't sit down on the 16th because of lack of resource. The respondents goes further to say that I have numerous counsels visiting me on legal basis. Your Honor, these counsels, as any person would understand, any counsel has a specialty, and I cannot take a counsel that says to me that they cannot take the legal obligation of representing an application that is not within their scope, where they will lack legal understanding. It is then within my own that if I can't defend myself, no one is going to defend me. I am the monster here. And if I'm not given an opportunity because somebody believes that my resources are enough, the court has full evidence. I have stated in the replying affidavit that I tried prior to drafting the application. I took about 14 months to draft the application that is before the court as the main application. And I've put it here. I've also added 5 different copies of different versions that I've handwritten myself of the same application. I have taken information from the first application, which was done by Mrs. Makutumana. And in that, I have tried to build my own defense. And I have done the best with the resources I have limited. And I have stated that from November the 6th, 2023, Correctional Services was the first time they allowed me to have books and access to information. This information is so-called limited. I cannot get the press, which I have highlighted in my affidavit. I cannot get the press briefing on the 8th of April, which was done by government, stating the reasons of deportation, which are fundamental in the main application. Your Honor, this application is not an application self-created. There are numerous attempts that is before the respondents where they have a complainant request book. If Your Honor could request the complainant request book, they have strategically not added the copy because it states how many times I have been denied access to books and access to legal information. At this point, if I had to write an application to request any documentation of legal reasons, I have to state the reason of my application. I have to state why and how long. And I feel that, Your Honor, in that current position, it is prejudice to me. Second thing, Your Honor, the respondent alleges that the application does not meet urgency. Urgency in the application could have never been self-created, Your Honor. The application has been brought by a person who does not have representation. Once counsel dismissed the brief, I cannot come here and disclose briefs that have not been accepted of counsel. That would be me being prejudiced to those counsel. I have to respect their decision. Any person has a right to take whatever brief they choose. And in that, Your Honor, I filed my own application. And in filing my application, I wrote a request, which I have here, which is in the reference book of complainant request 144, 2024, and 2023, requesting the respondents, may I please have you type my documents. At that time, I had no intentions of a laptop or anything. I just asked for access of typing. And in that, it was rejected. So, Your Honor, if the respondents say that this is self-created, I have requested to have access to this media briefs. They still rejected it. So I am not here asking that I am given a luxury of a laptop or anything else. In all events, if Your Honor, if you follow the process that I have followed all the internal issues, and I have then taken the matter to a point where I am now have to put an urgent application. And in the urgent application, the respondents did not have the application as they allege on the 23rd. They had the application on the 13th, when it was commissioned. The commissioning of oath has a stamp of the head of prison. He had it immediately. And they fully understood what my challenges were. From that point until now that we come before the court, I have been having back and forth. Your Honor, the register of this court will explain. Yesterday in the afternoon, I had to get an assistant of a third person to call the court to ask for a requisition. If I had not done that, I would not be before this court. And this court is digital. It is not my choice that the court goes digital. And it is absolutely would be unfair of me to expect a third party to do as I wish, when I wish, as in accessing my applications on my times. And I feel that the respondents have not proven at any point that I do not have, I have numerous access to legal resource. They are saying that I'm self-created. They are saying that I have access to legal visit. But Your Honor, a criminal attorney is a criminal attorney. We're talking about a civil matter. This is a civil matter before a civil process. And I cannot take somebody who's before a criminal matter who insists that they cannot represent me on a international civil matter to come and do that. Because they are bound by practice. of the attorney rules. I cannot do that. And in that, Your Honor, this application makes thorough sense that the respondents does not even touch on the fact that they can monitor access to a laptop. They can monitor access to internet. That the allegations that have been put before the court, I clearly stated to the respondent in my reply that I was released from prison. Facts further on that will be highlighted in a criminal matter. I cannot disclose any issue revolving the criminal issue. And I feel that, Your Honor, it is biased of the respondents to take the fact that I'm not able to commission this and say that I have not submitted. I cannot write 10 copies of this in handwriting. It's 11 pages. And I have numerous copies that I have to do. So I feel that the court can make the decision as I feel that it is already clear to me that I am not understood. Any person in this country, including inmates, are human beings that have the right to fight for their constitutional right. It's a fundamental in the Bill of Rights. Section 38 states that if any infringement of the Bill of Rights is enforced, you have the right to take legal action. I have taken that step, and I believe that I do not have access to legal resources that allows me to freely access this court meaningfully. I do not have meaningful access. There's a difference, Your Honor, between access that's limited, that deprives you of filing and taking litigation issues on time, and access that is freely within monetary with the respondents can truly manage. This is, I believe, not in the best interest of anyone. And in that, Your Honor, the Bill of Rights clearly states that we all have a right to fair, equality, justice, and law that is protected. I am supposed to benefit as freely as the respondents in the main application. Am I going to be able to benefit as they benefit from law and access the law? I am not. Your Honor, if the main application, which I've added here, is that they have taken 28 days to 32 days to file a notice of intentions to oppose. They've taken 30 days to oppose to the responding papers. I was not able to file an application to this court to notify the court that the respondents are delaying the process. I cannot do anything in the current circumstances that I'm in. And secondly, Your Honor, I have highlighted in this affidavit that, and in my founding affidavit and my responding affidavit, that I am not under normal circumstances incarcerated. I am under circumstances that are inhumane. I live in a cage, I exercise in a cage, I am by myself. I don't even have time. So does that mean that because I am Thabo Bester, I have no right to access to my constitutional right? Because if I listen to the respondents and I listen to the court's submission and understanding, I feel that it's already giving me the impression that I am prejudged on the fact that I am Thabo Bester. The facts before the court speaks for itself. I am not asking the court for anything. I have stated that in numerous countries there was libraries that were law libraries that had access to printing these documents and typing these documents. But CMEX does not have that resource. It does not have that assistant. It cannot even assist me with typing a document. As you can see, my responding affidavit is in handwriting copies and commissioned and sent to the court because I cannot get anyone to type it. And all I am asking the court is to consider these facts. And also, Your Honor, taking into consideration that the respondents argue that my application has no basis on the basis that I have numerous access to court. Your Honor, I am before this court. But as I've explained, and as the register and numerous correspondence that are to this application proves that it was a struggle to get before this court. Now, I am fighting for my life where I am going against 7 departments of government. Now, regardless if I am not Thabo Bester or Thabo Bester, but the law says that we are all equal. Now, I deserve same access. I deserve the same amount of protection from the law. And right now, I do not feel that even accepting this supplementary affidavit, that the court accepted without even asking, without hearing my response or hearing my opposing facts. And that confirms to me that I am not going to get a fair treatment. And I understand that it is what it is. But at the end of the day, it is my life that I am fighting for. All these allegations that the respondents has put before the court and the finding and the supporting affidavit, nothing has been proven. And if I had to entertain them to any level, I could shoot so many holes in that application. But because by law I am bound to take the matter before another court, the fraud allegations, I'm not charged. It is as good as any allegation put out by the media. How am I supposed to bring this and take these issues and address them to the court and test the evidence of it? I don't even have the proper annexures of the supplementary affidavit, Your Honor. And I request the court to understand that as a layman, there are mistakes I would make in this process. But it is the court's responsibility also to assist and guide me in certain factors. I have explained why this is not commissioned. I have explained my position why I have not been able to submit. But the court already, speaking to the counsel, already stated that the court does not care. And the court is not going to be entertaining whatever reason I have. And that is prejudice, and it's unfair.
Mr. Bester, I never said that.
Your Honor, you said that.
No, I did not say that. So let's move on from that. You chose to be heard at 2. You were given a full opportunity to file a response by Thursday. You chose to be heard at 2. You are sitting in the position you're sitting in because of your choice. And despite that, everything that you are hearing, not everything, but most of it, is not on the papers before. I am listening to you despite that. So please move on.
Your Honor,
Let's finalize this. You've made your submissions. Is there anything further? You are welcome to make further submissions, Mr. Bester.
Yeah, Your Honor, I just want to know how would I be able, because I have added this in my everything that I've stated now in my affidavit. Yeah.
You have told me that what you're telling me now is in your affidavit.
Yes. So I just want to know how would I get it to you, so since it's not before you.
You've made your submissions, Mr. Bester. Is there anything else you'd like to submit? Welcome.
Just on the closing point of my submissions, Your Honor, I want to state that under the current circumstances of the respondents depriving me of access to justice, Your Honor, I feel that it is unconstitutional and it is in the best interest of myself to be able to bring this application before the court and request the court to take in consideration the reliefs that I seek, and if any alternative reliefs can be provided or directive by the court in being able to provide me with any access that is meaningful to the current circumstances is all I seek. I pray to this court to take consideration that within the current circumstances, I have clearly stated what my position is, that I have given evidence beyond reasonable doubt that I am under circumstances where I cannot access even a diary. And because of those small factors, they make a huge difference. If you cannot take a diary of notes to a point where the court says I can access books, accessing hard copy material is as hard as accessing a diary. And in this current circumstances, the court, regardless of how the request or reliefs are appointed, all I am requesting is assistance to be able to file my main application. I am not requesting for a specific, as long as I have access. The respondents can provide any means or any way that they are able to provide me with meaningful access, that I'm able to access the evidence that I've stated, and that I'm able to file my application and be able to represent myself as best as I can, which is what I am constitutionally given. And I request the court to take that into consideration in this whole process.
This is an extemporary judgment. National 28 on my law, case number 06. 13th of August 2024, the applicant proposed a founding affidavit in support of a notice of motion. In that notice of motion, he set out an urgent application. He set down an urgent application for hearing in this court at 10 hours on Friday, 16th of August 2024, and sought inter alia the following relief, quote, to declaring the conduct of the respondents refusing the applicant meaningful legal access to court in preparation of his legal proceedings in the deportation application under case number 2024/07160, bracket, the deportation application, close bracket, to the Constitution and invalid in terms of sections 9, 10, 35, 32, 33, 34, and 35 and 38 of the Constitution of the Republic of South Africa 1996. 3. Declaring the conduct of the respondents in refusing the applicant's request to use a laptop or tablet or form of devices in the preparation of his application and have access to court online to be unconstitutional and invalid in terms of sections 9, 32, 33, and or 38 of the Constitution. 4. Declaring the conduct of the respondents in refusing the applicant's request to information by documents or interest in preparation of the application and further legal matters and research to be unconstitutional and invalid in terms of sections 9, 32, 33, and 38 of the Constitution. 5. Declaring the conduct of the respondents in refusing the applicant's request to use a modem and printer in preparation of this application and deportation application and access to court to be unconstitutional. 6. Declaring the conduct of in refusing the applicant's request to communicate or visit by expert and witnesses for the preparation of the application and legal matters or taking legal action to be unconstitutional and invalid in terms of sections 9(1) and or 33, 34, 35, and 38 of the Constitution. 7. Declaring the conduct of the respondent in refusing the applicant's request to use a diary in preparation of this application and deportation application, and planning for legal and anything pertaining to my life to be unconstitutional and invalid in terms of section 9, 33, 34, 35, and or 38 of the Constitution. Close quote. That application never realized on Friday the 16th of August 2024. The applicant explains, and I will deal with how the matter came to serve before me in the present founding affidavit, that he had trouble accessing the court online profile and he had trouble finding his papers. What is clear is that that application, the notice of motion for this set down on the 16th of August 2024, was actually served on the respondents after that particular date of hearing. Thus, the application was never heard on the 16th of August 2024. Suddenly, on the 10th of September 2024, the applicant set down the self-same application for hearing on the urgent roll of the 17th of September 2024. Between the initial application or deposing to the initial application on the 13th of August 2024 and the notice of set down, the applicant has abjectly failed not only to explain the more than 1 month delay, but failed to explain why he cannot obtain relief in due course. The state vehemently opposes this application and has explained to this court in its main answering affidavit that this is not the first time the applicant has sought this relief. In an application launched in the Free State High Court on 24 July 2024, the applicant similarly seeks the use of a personal laptop for purposes of preparation for his criminal trial, and thus it appears what the applicant seeks to do is forum shop in the event that a court will eventually hear his matter on an urgent basis. I pause to mention that I am informed that the applicant is, for purposes of his criminal trial and deportation application, represented. Insofar as his application for deportation is concerned, there is no urgency at all, as the papers in that application are not yet finalized, no heads of argument have been filed, and no court date has been provided as yet until that application is in full before court. Thus, on all views, the application before me is demonstrably lacking in urgency and cannot be entertained. As no costs were sought, no costs order will be made, thus the order made by this court is the following. The application is stopped with the roll for a lack of urgency.
As the court pleases.
Court will adjourn.